Good morning, ladies and gentlemen. My name is Judge Terrance Holmes. I'm the presiding judge here in County Court at Law Number 2. First of all, I'd like to welcome you to County Court at Law Number 2. You have been asked to come to court this morning for what is called an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Cases are divided into civil cases or misdemeanor cases. Civil cases or criminal cases. The case that you have here is a criminal case. Now, criminal cases are divided into felonies or misdemeanors. The case that you have in this court is a misdemeanor case. The difference between a felony and a misdemeanor, basically, your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. For example, felony cases are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. We have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, then they can be sentenced anywhere from a minimum of 6 months to a maximum of 2 years in state jail. They can be given a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the minimum is 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that because the offense that you have been charged with is classified as a misdemeanor. Misdemeanor offenses are divided into 3 categories. And we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is a fine that does not exceed $500. So you cannot get jail time for a Class C misdemeanor. Now, when I say a Class C misdemeanor, those cases that fall into that category are not wearing a seatbelt, speeding, have an expired license sticker, those type cases. And those are the cases actually, they start in the city court or the municipal court or the JP court, which is the justice court. They come to this court when a person is convicted in one of those courts, and then they will appeal their case. In essence, they would like to have a higher court to look at the case to see whether or not, to look at their case so that they can get a whole new trial. And so the case comes here. The punishment range does not change. It stays the same. You only could be given a fine up to $500. You can't get jail time. Now, if you fail to pay the fine, or if your fine was converted to community service and you fail to perform the community service, then they can issue what is called a capious pro fine. In essence, a warrant for you to sit out the fine. And you would have to sit out the fine in jail, and you receive $100 per day credit that will go toward the payment of your fine. So every day you sit in jail, it's $100 credit that will go toward the payment of that fine. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days or 6 months in the county jail, or a fine from $0 to $2,000, or you could be given both such fines and fine. The Class A misdemeanor, which is the highest misdemeanor, the range of punishment, if you're convicted, is 0 days to 365 days, which is a year in the county jail, or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may qualify for one of 2 types of probation. There's one type of probation is called unadjudicated probation. Unadjudicated probation is a form of probation whereby if you get on the probation, you will not have a conviction on your record. And if you complete that probation, you can get what is called a non-disclosure. In essence, your record will be sealed. It cannot be sealed. The general public cannot have access to it. Now, I use the word general public. The general public, that does not include the government. The government can have access. So any governmental agencies, police departments, school districts, etc., they can't have access. But the general public, which is most of the public, cannot have access to it. So that's called a non-disclosure. Now, the other type of probation is called adjudicated probation. We have unadjudicated probation and adjudicated probation. With adjudicated probation, we call it the regular probation. It does result in a conviction on your record. However, there's something that is called judicial clemency, whereby the judge can set aside your conviction. But in order for that to happen, you have to, one, successfully complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged off of the probation. If those 3 things happen, then the court can set aside your conviction. And if the court set aside your conviction, then you no longer have this conviction on your record. Now, if you get a subsequent conviction, that is, if you get another conviction later on for another case, then they can bring this other, the first case back up. In essence, the one you got judicial clemency on, that can be brought back up. It could be resurrected, revived, and brought back up and used against you. If you try to get a license from CPS, they can deny giving you a license, or they can suspend or revoke any license that you have with CPS. Okay. Now, the paperwork that you have, we're going to go over that paperwork. The first document should be titled, well, there's a document on that clipboard that is titled Judge's Explanation of Rights to Defendants Without Attorney. And on that document, it states, as a defendant in a criminal case, you have three options. Number one, and we talked about three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset to give you time to hire the attorney. Now, if you want an attorney, but you do not have enough money to hire an attorney, you will have to fill out a financial questionnaire. Now, the financial questionnaire is a form on that document that is titled Jefferson County Affidavit of Indigence. You will have to fill out the first page and half of the second page of that document so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, the third option is you may represent yourself. Now, if you want to represent yourself, you will have the opportunity to speak to one of the assistant district attorneys in the case. They work for the Jefferson County District Attorney's Office to see if you can work out an agreement to settle your case. Now, you may not speak to the prosecutor or the assistant criminal district attorney about your case unless you first sign a written waiver of your right to be represented by an attorney. The written waiver is also on that clipboard. It is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Once you read and sign that document, you'll have an opportunity to talk to one of the prosecutors to see if you can settle your case. Now, you should be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of that document that is titled Judge's Explanation of Rights to Defendants Without an Attorney, it states defendant's choice, marking issues next to one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if your choice is to waive your right to an attorney or to give up your right to an attorney, and you would like to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines on the Judge's Explanation of Rights to Defendants Without Attorney, then you will sign your name on the line that is titled Defendant, and you will date it today's date, May 21st of 2024. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney and you would like to represent yourself, then you will have to also read and sign the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And I'm going to go over this document with you. And it states as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Now, voluntarily means that you're doing it of your own free will. Nobody's forcing you to do it. Intelligently made means that you know what you're doing. So you're saying that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 21st day of May of 2024 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled Defendant, and you will date it today's date, May 21st of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. That area over there where there's 12 chairs are, we call that the jury box. 6 citizens will be selected to serve as jurors in your case. And they will listen to all the evidence, listen to the oral arguments, They will retire to deliberate, and then after they deliberate, they will decide whether to find you either not guilty or guilty of your charge. You also have a right to waive or give up your right to have a trial by jury. By waiving your right, that means that you will not be having a trial by jury. And if you waive your right to have a trial by jury, then your case will come before the court or before the judge in one of three ways. It can come before the judge by way of a trial. In essence, you don't want to have a jury trial, but you want to have a trial where the judge will be the judge and the jury. We call that a bench trial. And the judge will listen to the evidence, listen to arguments. The judge will decide to find you guilty or not guilty of your charges. The next thing, you also have a right. The other way that your case can come before the judge is by way of a plea bargain agreement. It can be either an agreed plea bargain agreement or an unagreed plea bargain agreement. And what a plea bargain is a settlement that you and the state have reached to settle your case. And that's as you and the state have talked, and y'all just and you come to an agreement to settle your case. We call that a plea bargain agreement. Now, if you have an agreement, the agreed plea bargain comes before the judge, and then the judge can either do one of two things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. If the judge rejects the plea bargain agreement, then you have a right to withdraw or take back your plea. In essence, you tell the judge, well, judge, since you're not accepting the plea bargain agreement, I take back my plea. In essence, I will not plead guilty, and I will not plead no contest. And you have a right to do that. Now, if the judge follows the plea bargain agreement, accepts the plea bargain agreement, then if you decide within 30 days that you would like to appeal your case, in essence, you would like to hire a court to review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you, then the judge has to give you permission to appeal. If the judge gives you permission to appeal, then your case will leave this court and it will go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. They will review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, and then basically your case will be over. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal your case to another court. You can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals. You will have to file what is called a pro se petition for discretionary review. Pro se petition basically means you'll be representing yourself. You won't have an attorney representing you. You'll be representing yourself, and you'll be petitioning the court or asking the Court of Criminal Appeals to review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. Now, they can do one of two things. They can either accept, or they can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty and the case is over. Or they can send the case back to the Ninth Court of Appeals, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your petition for discretionary review, then at that point your conviction will stand. Now, also you have a right to have, I talked about you having a right to have a trial by jury, or if you waive your right to have a trial by jury, you can have a bench trial, just a trial by judge only, or if you can enter into an agreed plea bargain agreement. The other agreement that you can enter into is what is called an unagreed plea bargain. In essence, you and the state have not been able to reach an agreement concerning your case, and you want the judge to decide what your punishment will be. The judge will listen to all of the facts in the case, review criminal records, and decide what punishment. And there's some other things that the judge would do to determine what will be an adequate punishment in this case. Now, you also have a right to have witnesses that come to court. Witnesses sit in that chair right there. We call that area the witness stand. And a witness, what they can do, they can testify. They can testify either for you or against you. If you have an attorney, if you represent yourself, you can ask some questions, or your attorney can ask some questions. We call that either direct examination or cross-examination. You also have a right to waive your right to call witnesses. And what I mean by that is, if you waive or give up the right to call witnesses, that means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case. You also have a Fifth Amendment right against self-incrimination. And with the Fifth Amendment right against self-incrimination, what that means is you have a right not to testify in your case. The government, the state of Texas, the district attorney's office cannot force you to take the witness stand in your case. Now, you can waive or give up your right, which means that you can take the witness stand on your own behalf if you decide to do so by waiving your Fifth Amendment right against self-incrimination. You also have a right to have what is called discovery. Discovery means you have a right to see the evidence that the state has against you. You have a right to have access to the evidence. You have a right to see witness statements, your statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings, or any type of instruments that the state is using or will be using in your case. You have a right to have access to that. Now, you also have a right to waive or give up your right to have discovery. If you waive or give up your right to have discovery, that simply means that you will not have access to the evidence that the state will be using against you. Jefferson County has a program. Well, first of all, everyone that's here today for court, you have been arrested and you're out of jail. And now you're out of jail because you're out of jail on what is called a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bondsman a percentage of the cash to get out of jail, or you're out of jail on a personal recognizance bond or a PR bond, which means that you did not have to pay any money to get out of jail. You are released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail can be used as punishment, can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail before you bonded out, and you're in the state, and your attorney in the state have talked, and they are offering for you to serve 5 days in jail. Well, that simply means that you will not serve 5 days in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the 5 days that you have already served. We call that credit for time served. Now, if they are offering 7 days in jail and you spend 5 days in jail, that simply means you will only have to serve 2 more days in jail because you have 5 days credit. So we take 5 from 7, that leaves 2. Every day that you spent in jail also can be used as credit toward your fine and court costs. For every 1 day that you spent in jail, $100 can be used toward your fine, and you'll be credited $100 toward your fine and court costs. So, for example, let's say the state is offering you fine and court costs of $500. You spent 5 days in jail. That means you will not have to pay any more money to get out of jail because you already have $500 credit that will go toward the $500 fine and court costs. If they are offering fine and court costs of $700, that simply means that you only have to pay $200 because we will subtract the $500 from the $700, and that leaves $200. And you'll be required to pay the $200 on the day that your case is disposed of. If you cannot pay the fine and court costs on the day that your case is disposed of, then we can put you on what is called a payment plan. That simply means that you can pay the amount over monthly installments. So, for example, you only pay so much each month until the total balance is paid off. Now, if you're unable to pay the balance off, that is, you don't have the money to pay the fine and court costs, even if we put you on a payment plan, no problem, because we can convert the fine and court costs to community service. You will work at a nonprofit organization to work off the fine and court costs. You will receive $12.50 for every 1 hour that you perform in community service. So in our scenario where we say that you owe $200, that's converted, so the $200 is converted to community service. It actually, what that means is you would have to work 16 hours, because 8 hours is $100, 16 hours is $200. So if you work 16 hours, that will pay off your fine and court costs. And basically, 16 hours is 2 days of community service at a nonprofit organization in Jefferson County. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. If you haven't been in trouble before, the Jefferson County District Attorney's Office, if you qualify for the program, they will dismiss your case. And if you complete the program, you can get it wiped off your record, which means you can get it expunged, deleted, wiped off, or erased from your record. In order to qualify for the program, as I mentioned earlier, this will be your first time getting in trouble. It has to be an offense. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you with making out the application to get into the program. And again, if you get into the program, you complete the program, case is dismissed, you can get it wiped off your record. Now, Jefferson County also has a program that is called Veterans Court. It's for veterans only. If you're veterans of anyone, if you are a veteran of any one of the military branches, with the Veterans Court program, it's also part of the pretrial diversion program. And with the Veterans Court, only thing you have to do to get into that program is be a veteran. And if you get into the program and complete the program, they will dismiss your case. And you can get it for what is called a non-disclosure. And a non-disclosure, as I mentioned earlier, is where they will seal the record to the general public. The general public cannot have access to your criminal record. And that's what that program is for veterans only. It's called Veterans Court. This court has a program that is called the CSI program. The CSI program is a program that I started in 2017 within the first 100 days of taking office. And that program, it started in March of 2017. And that program is designed to address the issue of what we call recidivism. Recidivism means people commit crimes over and over. So how do we address it? Well, we address it through the Community Safety Initiative. And with the Community Safety Initiative, is designed to make Jefferson County a safer place for all of us to work, live, go to school, raise our families, go to church. And the way the program operates, we have partnership with local agencies. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas region. And what Spindletop will do, Spindletop can address any mental health needs. They will conduct a private interview. They will do an assessment, and they develop a treatment plan for either outpatient or inpatient treatment, depending on your mental health needs. Now, you do not have to be incompetent or insane to be in the program. You can just merely suffer from anxiety or depression or any host of any other mental illnesses. And they have the expertise to address those issues. Now, Spindletop, we have some folks on Spindletop here today. They're going to come to you in a few minutes and tell you more about the program that Spindletop has to offer. Now, Spindletop also has a program that is called ATAR. ATAR is a program that is a drug and alcohol recovery program. ATAR stands for Addiction, Treatment, and Recovery. That program is designed to address individuals who may have issues with alcohol or drugs. They will do, and we also have a partnership with Ozar. Ozar is through our local drug and alcohol council program that we have a partnership with, and the Ozar stands for Outreach, Screening, Assessment, and Referral. Both programs, ATAR and Ozar, are drug and alcohol recovery programs, and both can address any problems that individuals have with alcohol or drugs. They will do a screening, a private screening, an assessment, and then they can refer you to either outpatient or inpatient treatment, depending on your needs. If you are unemployed or if you are looking for a better job, we have a partnership with the Golden Triangle Empowerment Center that has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry and the chemical industry. Once you are trained in any one of the areas that you select, they will assist you or help you to get a job in the area that you're trained in. If you have not graduated from high school and you would like to get your GED, well, CICE has a GED program where you can get your graduate equivalency diploma. All these programs that I just mentioned to you, which is part of the CSI program, are free. It does not cost you anything but time. And in this court, I like to say that we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I tell people this all the time. When you come to county court at law number 2, we do not have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, then we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. And so with the programs that we have to offer, is making Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. Now, the folks in Spindletop is going to come to you in a few minutes, and they're going to tell you more about the program that they have to offer. And then once they come, then we're going to go into recess. And when we go into recess, what we're going to do is we're going to pick up the paperwork that you have on the clipboard, and then we're going to call you up before the bench. We're going to call you up one at a time to go over that paperwork. And either you're going to be put in the category of wanting to hire an attorney, or wanting to apply for a court-appointed attorney, or you might want to waive your right to an attorney and to represent yourself. Now, it's going to take us a few minutes, so it's going to take us a little time to pick up the paperwork and to evaluate it and to go through the paperwork. If you need help with the paperwork, we have our court personnel who's here, who will be happy to help you with that paperwork. Now, as I mentioned, it's going to take us a little time to go through that paperwork. You might want to use the restroom. There are 2 restrooms that are right outside in the hallway. There is the men's restroom, which is in front of County Court at Law number 3, which is next door to this court. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court, okay? So before we go into recess, we have Deputy Hinton, who's here, who's from Spindletop. He's going to tell you more about the program that Spindletop has to offer. Deputy Hinton.
Thank you, Mark.
You're welcome.
Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the State Commission here with the Sheriff's Office. I also have a qualified mental health professional. She's in the other court, but she will also be available. The reason we are both here this morning in this courtroom is because the judge cares about every single person that comes before the bench. What the judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with their situation. Now, this may be your first time to be in court, could be your 10th time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're going to need something from you. Now, I passed this out earlier. I hope everyone got one. It's the demographic sheet. This is a form where you can actually tell us what your needs are very privately. We'll pick this up shortly. The judge goes into recess, and we'll be able to visit with you at that time, and we'll answer any questions you have. And I'll also use that opportunity to pass out one of these to everyone as well, so we'll have this. It's a flyer. It has some advantages of actually participating on the back. It also has a 1-800 number. If you ever find yourself in an unsafe place, you can call that number and get help immediately. Just shortly, the court's going to go in recess, and when it does, and I'll be able to come out there. I'll visit with you, answer any questions, and I'll pick up those documents and hand this out to you all as well as that time. Thank you. Thank you, Your Honor.
Okay, you're welcome. Thank you, Deputy Hinton. Ladies and gentlemen, as I mentioned earlier, if you need any help with filling out the paperwork, we have our court personnel who's here to help you with the paperwork. And for those of you who might need help with your paperwork, just simply raise your hand, identifying yourself, and then we'll either come out to you, or we'll ask you to come up here, and then we'll go over the paperwork and help you with that paperwork. So at this time, we will go into recess. Now, I did mention that there are 2 restrooms in the hallway. You can go use the restroom. When you finish using the restroom, please come back into the courtroom. Do not leave the courthouse. If you leave the courthouse and your name is called, then your bond will probably be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. But do not leave the courthouse. So if you need to use the restroom, you can go use the restroom, and then you can come back into the courtroom. And again, if you need any assistance at filling out the paperwork, just let us know, and then we'll give you the assistance that you need. So at this time, the court will be we'll go into recess.